Hello and welcome to Past, Present, and Future, where we discuss the nuances of cases related to the past, the present, and the future implications. Joining us today, we have Maura Masterson doing the past, Jeremy Davis doing the present, and yours truly, Nick Burgos, doing the future. Jeremy Davis, could you fill us in on what this case is about?
Absolutely. Essentially, Student M, JFS, is a privately funded Orthodox Jewish day school, and it's expressly Orthodox Jewish, outlined in the statement of the school ethos. It teaches Orthodox Jewish values and teaching. He's disclosed M for confidentiality, and the parents decided to apply for admission into the Jewish Free School in London, England. Admission preference is given to those who, quote, are recognized as being Jewish by the office of the chief rabbi. So the parents of M, the father was a practicing conservative Jew, and the mother was born a Roman Catholic Italian. Orthodox Jewish law contends that in order to be considered Jewish, regardless of the degree of practice, one's mother must be Jewish or you must convert under an Orthodox rabbi. Just for clarification, there are three main degrees of Judaism: Reform, Conservative, and Orthodox. Orthodox being the most traditional, Reform being the most lenient. When the school denied admission priority, the father sued under the Race Relations Act of 1976. With the Race Relations Act, essentially, is you can't discriminate via race, nationality, or ethnicity. So the key question is, can Judaism be classified under any of these? And if so, does M win the case? I'll now turn it over to Maura to discuss the past.
Thank you, Jeremy. So, the reason this case is so complicated has to do with England's kind of vague and interesting relationship with religious freedom. So, everyone knows that the English government, Great Britain, does have, there's the Church of England, and they decreed in 1701 that the monarch of Great Britain shall join in communion with the Church of England. However, there is religious freedom that was protected under Article 9 of the Human Rights Act of 1998 at the European Convention. And this allowed the right to wear religious specific uniforms in school, the right to wear religious clothing at work, things like that. And even though funding isn't relevant in this case, um, religious discrimination in private schools is legal. And but that's why this case is so complicated, because there is also precedent with the Brother Daniels case from the 60s, where a Catholic monk who actually had a Jewish mother assumed that he would be granted Israeli citizenship immediately for having lineage, and he wasn't, because he had been a Catholic monk his whole life. So this sort of complicates the question even more of whether or not Judaism is a race, a religion, an ethnicity. And to touch on what Jeremy talked about with the different kinds of Judaism, Reform Judaism counts patrilineal descent, but the JFS school, they are Orthodox, so they only count matrilineal descent. And I'll turn it over to Jeremy Davis for the present.
So there are some key questions that the court had to decide. I'd like to discuss those in two major clumps. First of all, who gets to be part of a religious group? How do you determine? Is it up to the state to determine, or is it an internal affair? Is the group considered solely a religious group, or is there something more to just being a religious group? And when can you join and when can you leave? For the first point, in the Jewish faith, as Mara said, it's either conversion or matrilineal descent, and it gets dicey depending on who you ask. As Reform Rabbi Bayfield states, conversion has been a feature of Jewish life for thousands of years. It's been most prolific when Jews have lived in tolerant, open societies, and least prolific when Jews have been persecuted and state law has prohibited conversion to Judaism. So when you compare this to the Lena Joy versus Religious Council of the Federal Territories, which was a case in Malaysia pertaining to personal freedom and religious autonomy, essentially Joy wanted to get out of Islam to marry a Christian male. And obviously there's direct contrast, because in this case, in the JFS case, the student M wanted to be Jewish for education, but in the Malaysia case, the lady does not want to be Muslim. When they ruled in favor of the of the religious group in Malaysia, both conservatives and liberals were very upset. And that could be the case in the JFS, as we'll later find out. So returning back to the JFS case, Lady Hale, in a very famous quote, she states, M was rejected because of his mother's ethnic origins, which were Italian and Roman Catholic. The fact that the office of the chief rabbi would have overlooked his mother's Italian origins had she converted to Judaism in a procedure which they would recognize makes no difference to the fundamental fact. M was rejected not because of who he is, but because of who his mother is. That in itself is not enough. So I find this reasoning to be partially correct, a half-truth. It's not who M's mother is necessarily, but what she did. And what I mean by that is part of becoming Jewish is conversion, which she did. That's action and not inheritance. Conversion includes many hours of study. So when I think of this, I think it's sort of like the difference between standardized testing for undergraduate admissions versus graduate admissions. One is significantly much more difficult than the other. And also, so we have to take a look at the relevancy to other examples. When I think of this, I think of legacy and college admissions. So what if a private university only accepts legacies? That begs the question, should colleges be sued for including legacy in admissions? Well, they've certainly been sued for race-related problems. It's certainly a question of affirmative action when you look at Grutter v. Bollinger and the Regents of the University of California v. Bakke. So the second key question that the court had to deal with were the differences in race, ethnicity, religion, and nationality. When we talk about nationality, it's where someone is born or the citizenship that they hold. So when you think of Americans, not all Americans are Jewish. I found this relevant that recently the Trump administration, and I passed an executive order, which, and I quote, a White House official confirmed to CNN that the order would interpret Judaism as a nationality and not just a religion to protect against discrimination in the Title IX violations. So I think we can cross that one out. The court certainly crossed out nationality. When we think of race, that generally refers to a group of people who have in common some visible physical traits. And I think we can get rid of this one too. As Lady Hale pointed out, no one in this case is accusing JFS or the office of the chief rabbi of discrimination on the grounds of race as such. So that leaves the final two, religion and ethnicity. And how do you differentiate between the two? Well, Lord Fraser pointed out the 7 characteristics of an ethnic group: long shared history, cultural tradition, common ancestors, common geographic origin, common language, common literature, and being a minority or a dominant group in a larger community. So these are somewhat subjective. And when I think of this, I think, well, the King of England is chosen by bloodline, and there's certainly some shared ethnicity and national origin. So couldn't that be somewhat hypocritical? And isn't that unlawful under the Race Relations Act, considering that the Church of England and the government are aligned, as Maura pointed out? So again, the deciding question, is Judaism more of a religion or an ethnicity? Certainly some gray area. As Rubens pointed out, religion has evolved over time, and that the current usage of religion is popularly defined in the Protestant Christian mode. Religion is seen as the voluntary faith and or belief of an autonomous individual. And certainly there's autonomy within Judaism. Not all Jews keep kosher, and not all Jews go to shul on Sabbath. So if religion is seen in the Christian mode, how can the court equate the same definition to a non-Christian religion? And this is the final question I'll leave you with. Should non-Christian elements be forced into the Christian way of thinking? Nick, I'll turn it over to you.
Thank you, Jeremy, for that wonderful discussion about the present implications of the JFS case. Now, for the future and what lies ahead, my main concern is we saw that the school does not implement that sort of determination anymore. They do not determine religion based on matrilineal descent. So they've implemented this sort of form that one would have to fill out, and then it has a list of categories like how many times a year have you attended synagogue, or like how many places that you volunteered at. And so my main concern with that is the categories. If more schools implement this way of determining your religion, then what categories will they implement, and what that could mean for other countries if this way of determining religion gets spread countrywide, you know. So
makes it more faith-based.
So it does make it more faith-based, but then comes the question of if they implemented a system where one of the categories would be religious wear and how many times religious wear is worn, what would that look like across different countries all over Europe? So for instance, in France, religious wear, such as burqas, are banned in public settings. That includes public schools. However, they are allowed in places like private schools. So if preferential admission were given based on the criteria, how many times religious garb would be worn, that could then be considered a class issue due to only private schools allowing this wearing of the religious garb. And that could then have further implications due to discrimination based on poverty, which is not fun because private school, you have to pay money for it. But I just want to get a brief discussion of this Church of England. The head of the church is based on descent, correct?
Mm-hmm. So I mean, so is the King of England, and I mean his bloodlines. I just find this to be somewhat hypocritical when the court rules the way that they did, and yet the King of England stems from a bloodline. It's not who the king is; it's who his parents were.
I think all Jewish denominations allow for conversion, so it's interesting that they didn't allow that.
Right, and also, I mean, I felt that this was an internal affair because, I mean, who gets to be Jewish? Who gets to be part of the in-group? That's determined by the people within the group. And it's been that way for thousands of years, as the one rabbi pointed out.
I think also like a problem here was the in-group wasn't really specified because here we have two different types of Jewish, right? Seeking where this father and this son was a different type of Jewish than the school, but they were seeking preferential admission because the school said that they would give all Jewish students preferential admission. So would this case have panned out differently if the school specified that it only allowed Orthodox Jews preferential admission rather than all Jewish students?
So no, when I think of this, I think, what happens if it were to a Christian school? Who gets to be Christian? These are certainly roadblocks in the questions that we debated throughout the semester.
And then will we see a sort of shift from baptizing children? Because in here, the religious criteria was based off of the mother's choice to convert. So would then baptizing your kid, it being like the parent's choice, will that then phase out due to this new ruling? Thank you for listening to this analysis about the JFS case, and we hope that it brought some interesting, thought-provoking questions and also some different perspectives when it comes to analyzing this case and its implications for the future as a whole.
For sure. Glad to be here.
Thanks, guys.
Period.